Attendant, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning, members of the board. Can you hear us? Okay. Yes. Okay. Try that. We're getting go. Okay, let's try that one more. Can you hear me now? I don't have my microphone on. Yes. Are we good to go?
You want me to try from lectern?
That'd be great. Thank you. We don't want to have an echo through the whole conversation.
I'm testing the microphone. Can you hear me? Justice Zamar? Great.
Great. Thank you. Thank you for doing that. Thanks, Ted. All right, this is S-1-SC-39065 Blanchard Corona Ranch versus. Can I have entries of appearance, please?
Good morning, John Sullivan, Public Land, and with me, sorry, you're not. State line.
Good morning, Your Honor. Pete Domenici and Lorraine Collinsworth for Blanchard Ranch.
Thank you very much. Nice to see all of you. All right, Mr. Sullivan, it looks like you have reserved 20 minutes for your argument in chief, 10 minutes for rebuttal. Is that correct? Correct. All right. Go ahead and take the podium.
Chief Justice Bacon, and may it please the court. Commissioner of Public Lands exercises custody and control of roughly 9 million acres of state trust lands scattered throughout the state. There are state trust lands in every county in the state of New Mexico. There's additionally roughly 4 million acres of split estate minerals that are part of the state trust, where the so-called surface estate is owned by somebody other than the state. Commissioner oversees the State Land Office, which administers roughly 3,500 5-year agricultural leases, most of which are for livestock grazing. And there are a host of other instruments allowing for additional occupation and use of state trust lands that overlap almost always with some portion of an agricultural lease. There are over 6,200 active oil and gas leases, most if not all of which are on land included in an agricultural lease. There are roughly 20,000 easements for roads, oil and gas pipelines, utility lines, and the like. And there are almost 30 renewable energy wind leases and 12 solar leases. When it comes to getting sued in state court in connection with all of this activity, the commissioner and the State Land Office want and need to know what the rules of the road are, including proper venue. The venue statute, section 38.3-1-3-1, has a provision, paragraph G, specific to suits against state officials requiring such suits to be filed either in Santa Fe or where the plaintiff resides. The venue statute contains a potentially competing provision, paragraph D, specific to suits which have lands or an interest in lands as their object. Both of these provisions are very long-standing. There has not been a lot of decisional law with regard to paragraph G, suits against state officials, probably because that has a relatively straightforward meaning. Conversely, there is a fairly extensive body of decisional law as it relates to paragraph D, suits where land or an interest in land is the object of the suit, because of its distinctive phraseology and because of the potential conflict with yet another provision, paragraph E, pertaining to suits for trespass on land. As shown in the K-Walk Court's lengthy and exhaustive discussion of the venue statute, and paragraph D in particular, paragraph D and the phraseology referring to suits which have land or an interest in land as their object has a distinctly narrow meaning. It does not mean, as the district court here seems to have ruled, any action which has an interest in land as part of the subject matter. Instead,
Distinguishing subject matter from object.
correct. So this word object has a particular significance and meaning when you take it in the overall context. And the K-Walk Court did this sort of, I wouldn't say ad nauseum, but very extensively as sort of why you end up in that place. And one of the most immediate things is that you have a provision that also is specific to land. It talks about trespass.
So why is it taking the leaseholder position? Why isn't the potential harm to their ability to graze an object in land?
Well, and the K-Walk Court talks about this, and we agree completely with what the court said there, and they have taken no issue with that. And the answer to the question is that object of the suit means that you are seeking to create, transfer, or revoke ownership of the land or an interest in the land. And that's not what's at issue here.
Well, Mr. Sullivan, the statute also says in whole or in part. So what you're saying does make sense if the in part was not there. So what is the in whole or in part? How does that play into it?
So I think our argument here is that no part of this suit involves creating, transferring, or revoking an ownership interest in either the land or an interest in the land.
It would have, so in essence, your position is unless your client does something that changes the title, venue does not belong in that county. Literally divest, changes title.
Well, there can be other interests that I guess conceivably could be non-title interests. I think particularly as it relates to the state land office, it's worth noting that all of the title records are in the state land office here in Santa Fe, and that's not a local matter as far as any
So
particular
it's not like
county is
running it
concerned.
through a local title.
Correct. And there's nothing at issue in this case that involves that kind of title record where you are looking at county records.
So you would distinguish, create, transfer, or revoke from arguments related to impairment.
Exactly so. And it's not just my position. The K-Walk Court explains this at some length as to how you end up there. And so I think we're not arguing a new position. I mean, that's a Court of Appeals case. This court can examine that and decide whether it agrees. But in that regard, I think it's also worth noting that no one is taking issue with that standard that was articulated in K-Walk. We're simply repeating the standard that the K-Walk Court used.
Well, that's fine, except we need to know why that is a good standard. I mean,
No.
I appreciate that. I'm interested in really why. And another interesting part of this is, and I'm going to ask Mr. Minichi this if he's presenting, but this arises in contract, it seems to me. You have it's not the principal object, it's really a contract dispute as much as anything. Right?
Correct.
Because, so, I don't know whether that bears on the analysis or not, but I'm really, at least I'm concerned, I'm not concerned. I'm interested in why this reading that you're espousing makes sense.
So, and just to be clear, I'm going to be repeating things that the K-Walk court does throughout its opinion. One of those things is this distinctive phraseology where land or an interest in land is the object. That's a distinctive phraseology. You are trying to harmonize that with other provisions of the law, including a part of the venue statute that talks about trespass to land. So you have another land provision right there in the venue statute that's telling you just because land is involved doesn't mean
But I think
that you're within
I
paragraph
think they're gonna get up and say, it's because our interest is involved.
Possessory interest.
Yeah,
well, and
leasehold or fee. Right.
well, and the idea, as far as the venue statute is concerned, is there's nothing involved in terms of creating, transferring, or revoking that interest. They have a lease. No one has disavowed the lease that they have. No one has sought to dispossess them. What they are saying is the issuance of a lease, a wind lease that partially overlaps with our lease, is interfering with our lease.
Well,
That's
cows
just,
aren't gonna go graze on the base of a wind turbine.
correct.
It takes away some of the grazing that they had here before.
But they still have the right, so they still
They have
have,
the right to eat the concrete or whatever it is.
well, no, our argument isn't that and so the interest that they have under the lease is subject to the terms and conditions of the lease, which includes a reservation of the right to issue renewable leases
As well as getting permission of the leasee.
and which
Which
is
was
written
not
into
done
the
in this
lease. So
case,
what we
according
have
to-
at issue is a party that's disavowing and it's saying they don't like the lease that they signed that says very
So
quite
it-
explicitly.
Isn't then the gravamen of the dispute between the parties here is how those leases came about? It's really looking at contract, not real property, and your regulations and whether you follow them.
Well, I think it's rule based.
I think that's a good
And-
summary of it. It's rule-based. This isn't really about title at this point. This
Correct.
is about the mechanism by which these wind turbine leases were created.
And there's no contention that the land office and the state's ownership of the land doesn't provide for issuing wind leases, period.
And
It's
no matter
that-
what we decide in this case, either way, it has nothing to do with title.
Correct. I mean, certainly in terms of what we're doing here, which is simply deciding what the forum.
It may come up later, but right now, what the issue on appeal is not related to title.
Certainly the substantive merits of the claim that are being made are not present. The question is where that's to be litigated. And the issues under the venue statute are ones of convenience of the parties and equity as far as that's concerned, and compliance with a statute that says where suits are to be filed. And I think my opening is intended to indicate that we have a running interest as far as this is concerned. It's not a one-off where somebody can simply decide, well, what difference does it make to the commissioner to do it and to litigate this thing in Lincoln County versus Bernalillo County or Santa Fe County. We're trying to figure out and know and get some certainty or at least some more guidance in terms of what the rules of the road are.
Dispute between parties has nothing to do with the title. There's land certainly here, but even the dispute's not about the land. The dispute's about whether you follow the rules.
In issuing the wind leases, correct. And so, and in terms of the interest that has been invoked and that was referred to by the district court and that they rely on in the briefs that they filed, the interest that they're asserting is their agricultural lease, and there's been nothing done to dispossess. I mean, there is a certain amount of use that's potentially going to exist. the extent to which that occurs during the term of this 5-year lease, when most of what occurs at the beginning of a wind lease is due diligence type of things, I guess, is something that we don't quite know.
It almost strikes me like if you're having a party's having a disagreement, files a lawsuit against an insurance company because they haven't paid a claim for water damage to a house. Certainly the case is tethered to property, but the dispute's not actually about the property.
Correct. And the K-Wall case involved a lot of different things in terms of the land itself, in terms of what was happening there. But the emphasis in terms of the interpretation of paragraph D of the venue statute is the object of the lawsuit having to do with some end result in terms of ownership. And indeed, there's ownership interest that's introduced in the case, and that's not enough to get you into paragraph D because it's not determining it as to the whole world. And so there's a lot of discussion there distinguishing in rem type proceedings from in personam proceedings. The idea being we're not adjudicating this as to the world at large. We're just adjudicating it for purposes of determining whether there was a trespass here or not. So in Professor Ocalino's formulation of this, as quoted by this court in the Team Bank versus Meridian Oil case, where the action, though related in some way to land, will not have an impact on title, there's no need to require the action to be brought where the land is located. So what actions create, revoke, or transfer an interest in land? The K-Wall court mentions some of them, equating them with the kinds of things that involve in rem jurisdiction. Quiet title actions, partition actions, foreclosure of a mortgage or lien.
How about possession?
I'm sorry?
How about right to possession?
If it's an ownership or a title
Possession.
interest. I'm sorry?
Right to possession.
So if it's if what's at issue is creating, revoking, or transferring that, then you're within paragraph D. If you're saying
Okay,
that somebody's
well,
done something to impair that,
I understand.
such as a trespass.
I
I'm sorry.
understand the parsing that's going on.
Mhm.
But in this case, if they follow the rules, if your client followed the rules, there's an automatic dispossession of certain amount of the land. If she didn't follow the rules, then he's entitled to possession of those parts that would otherwise have been leased for a solar.
Well, Justice Vihel, I don't really think that it's a dispossession if it's in accordance with the terms and conditions in the lease
But
and
if
the
it's
state
not-
land office rules that are incorporated in them.
What I'm saying is, whether it is or isn't, is what the case is going to decide. But the ramification of that decision affects possession of the land.
As does a trespass claim. And so what the K-Wall court
No,
is
it
trying to
doesn't.
do is
A trespass
reconcile.
claim is different.
I'm sorry?
A trespass claim is different because the trespasser doesn't have a right to possession necessarily. Right? And so, I mean, a trespass claim takes on many forms.
Right.
I see this as a little bit different.
Okay.
There's only two parties. The ranch as the leasee and the state land office commissioner as the leaseor. And whether the rules were followed, automatically, it seems to me, has an effect on who has the right to possess parts of that leasehold interest, whether it's for solar, wind, or for grazing.
And so they've been granted a right under the lease that no one is disavowing. The question is whether the grant of the additional wind lease is something that the state land office can or can't do by virtue of the rule, not as an ownership or title matter, but in compliance with the rules. So
I'm sorry.
there is a certain amount of, I'm sorry to interrupt, but there's a certain amount of parsing that results from the way the venue statute is written and the way these cases arise. And I'm trying to.
I don't want to monopolize your time, but I understand. Thank you.
What type of action could a leaseholder bring to satisfy the venue provision?
So if they're
Meaning the venue provision of having it located where they would like it located? Is there an action that a leaseholder could bring? They don't have title on the land. So any action by your client wouldn't divest them of it.
If they're claiming a title interest, they could bring a quiet title.
What about a
action.
constructive eviction?
Um,
If they said you constructively evicted us from this property by letting this wind company come in and take over,
mhm.
would that be under section D or under section G?
It's getting closer to a dispossession. And I think what's noteworthy here is the type of relief that's requested is declaratory relief. And if you look through, it's paragraphs 47 through 51 of the complaint that have their request for declaratory relief. And none of those things are saying you need to, that somebody's telling us we need to get out and we want to declare that we don't have to get out. In fact, the practical impact of the declaratory relief that they're seeking, I think, is one that is uncertain. But what seems more clear is that it doesn't bring them within paragraph D of the venue statute. There are a couple of things that I wanted to touch on that potentially impact, but don't directly perhaps impact. One of which is that to the extent that an ownership interest is at issue, there isn't an immunity statute. It's 42-11-1 that says that the state and its agencies are immune and may not be named as a defendant in any suit, action, case, or legal proceeding involving a claim of title to or interest in real property except as authorized by law. And this court interpreted that in the Nash case in 2021. And so to the extent, to a large extent, if you're pleading into paragraph D, you're pleading yourself into an immunity. To the extent that you're pleading yourself around the immunity, you're pleading yourself out of paragraph D. The other thing I wanted to note is that there is a contest statute that says that a person claiming any right, title, or interest, or priority of claim in or to state trust land can bring a contest in front of the commissioner. So to the extent that it's important in terms of where these things get hashed out, the legislature has indicated you can hash them out in an administrative proceeding before the Commissioner of Public Lands. And so from a policy perspective, I'm sorry?
Would that have to be in Santa Fe?
Yes. I mean, I don't have any experience with somebody requesting to have a contest. I mean, we could do a site visit or something along those lines, but yeah, those are generally conducted in Santa Fe. So the request that we have is that the court reverse the district court with directions to dismiss the case for improper venue. Thank you.
Thank you. Mr. Domenici.
Good morning, may it please the court. The complaint in this matter seeks relief specifically indicated in the prayer for relief that the district judge declare that the wind lease is void and unenforceable. So to the extent the object of the case might be perceived as something other than that, that is exactly what the object of this case is, to declare a lease void and unenforceable.
Are you asking us to overturn K-Wall?
Absolutely not, but I
Why
am.
not? Because it seems to be in direct conflict with the client's position.
Oh, it is not, Your Honor. In fact,
Tell me why.
well, first of all, K-Wall, so the statement regarding create, transfer, or revoke is made in the context of a trespass claim only. The actual holding in the case, at least from our point of view, is on paragraph 38, which says, and this is in our brief, this is the last line of that subpart. Our venue statute language In subsection D1 regarding actions which have as their object lands or any interest in lands as those which have ownership or possession interest in property as their direct purpose. This claim is being brought under the possessory interest that my client acquired with their agricultural lease. This claim is brought to void what we contend is an illegal possessory interest attempting to be established directly on top of our client's possessory interest.
But it's broad. Paragraph 43 of your complaint states, paragraph 21 of the lease, which is the contract provision. It's a lease, it's a contract provision. Does not conform with or meet the requirements of statutory or regulatory provisions related to the reservation of rights and the issuance of business leases for lands already leased. It's not an enforceable position. You have brought a contract claim. There's nothing that in this decision written by this court that's going to change the title to this property. There's no outcome we could come to as it's pled, or the trial court could come to that's going to affect the title to this property. So how then is venue proper?
Because it affects the possession of the property, Your Honor.
But that's not what our case law, if you read our case law holistically, that's what our case law says. If we look at Team Bank versus Meridian Oil, this court very clearly says it will not have an impact on title. There is no need to require the action to be brought where the land is located. And we know that historically, when we're talking about title, we require the case to be brought in the locale because that's where the title records live. They don't live in the land, they're gonna live in out. And so it's not just K-Wall, it's also Team Bank case that says it's not about title. We're not talking about the venue statute that you can get.
Your Honor, if I may refer you to the lease, the wind lease, first of all. The wind lease indicates that its final paragraph of the lease runs with the land. This lease touches and concerns the land and is a covenant running with the land for the duration of the lease.
I understand that, but that doesn't mean that your complaint is about title to the land. We don't, I think that it's premature. The potential impact on your interest lies in the future. We have to figure out the regulatory piece first and figure out if the state land office did it the right way or the wrong way. But its impact ultimately on your possessory interest, which arguably your client gave away through the ground lease, really isn't the debate in front of us. It's whether the state land office followed the rules.
Your Honor, with that analysis, frankly, any quiet title that's based on a suspect deed.
Because that's about the actual title to the property. I don't think we want to get into a debate about quiet title. I know that you and I both have a fair amount of experience with quiet title. That's about the title to the property. This case is not about the title.
Your Honor, the same is true if you were doing a quiet title that involves leasehold interests and trying to establish what lease has priority over another lease, which is very common in my.
That's not this case.
That is this case. They are attempting to create a priority of a wind lease on top of an agricultural lease. That's exactly what they are trying to do. That's exactly what the result is. And as the district court noted.
But the fight is about how they got there. It's not about the actual title. I mean, I can read your complaint. I've looked at it, I've tried to tease it out. I walked through it, and 2 of your claims are based on contract and 2 are based on regulation. They're not about priority at this point. It's about the mechanics and the procedure of how they got there.
Your Honor, we have a case on the redemption, on a redemption of a mortgage, that where the court clearly, and that there was an effort to bring that redemption case outside of the county where the redemption was taking place. And the exact argument you were making was rejected by a prior court. The party in that said, we should be able to go to Santa Fe. This is interpreting a redemption statute and how it applies and what the amount of the redemption is. And this court said that this case is not strictly about interpreting the redemption statute. It is about then applying and enforcing the relief that would be allowed. And we're not going to let these claims be split.
So how does the relief you're requesting, which is to declare the wind lease null and void, not saying that they can't have a wind lease, just this particular one because of procedural deficiencies, how is that the same as the redemption case?
It's exactly the same in that.
But why? Tell me why.
I am going to. It is because the result of their application and interpretation of their statutes, which don't include this reservation, by the way, just to be clear, all the reservations in that lease are by statute, except for this reservation. So, and I don't want to do the merits, but they've argued that to some extent. So that's at the heart of this is why can you put a non-statutory, non-regulatory, there's no rule allowing this into this lease. But the same was true in the redemption case. They were arguing over how the amount was calculated pursuant to a statute that was determined between the parties. And regardless of where that is, and maybe it is transitory, that aspect, just like this aspect might be, the relief is to void the lease. And if the district court voids their lease under the Declaratory Judgment Act, and they continue to pursue that lease, we're entitled to supplemental relief under the Declaratory Judgment Act. It's part of the act. That's how easements are enforced. That's how virtually all land title or possession issues decided by the Declaratory Judgment Act are not typically required to be enforced unless someone violates that. And then the district court that issued those has authority, statutory authority to afford the relief.
I think you misread part of the question and saying that they can go back to the drawing board because your client agreed that there could be these types of leases. So they just go back to the drawing board and take a run at it, not that they would violate.
But we're not trying to prevent them from going back to take a run at it.
But so to me, there's nothing that changes about your possessory interest if we say, go back, start all over again.
Well, currently,
That would be the drawing board.
well, I drove to Vaughan, and those towers clearly look to me like a possessory interest in that land. When you see those red lights covering down there hundreds of thousands of acres, that's an obvious possessory interest. And that is what this lease allows them to do. They may say it's not in the record, but they may say they're in the development phase. We had no way of knowing that when we filed this lawsuit. They didn't even give us notice of this lease. They could have controlled venue easily. They're concerned that they can't be sued around the state. Give us notice. We'll have to follow the contest procedures. We're in a district court asking for preliminary injunction. They issue over the exact lease, they issue it, provide no notice to us. So they're the ones who surrendered venue. That's our position. They could have followed their rules and we would certainly be in a contest provision.
I think that's my point, is that we're talking about procedural rules and notice. We're not actually getting to the next step that you want us to.
Well, if they followed the rules, yes, I agree with you. But when they didn't, we're entitled to file a Declaratory Judgment Act, which the district judge has ruled, and which they haven't chosen to try an interlocutory appeal on, because the law on that's pretty clear that under certain circumstances, when there's a failure to allow administrative remedies, a declaratory judgment becomes appropriate, which is our remedy. And the object of that is to void this lease. The location of the lease is in the county we filed. The possession regarding that lease is in that county. Their possession or their tenant's possession, it's basically a landlord telling a tenant, we're going to issue a lease right on top of you. And we don't care what you say, and we don't have to follow our rules. And you have to sue us. So we're the landlord. private landlord, we live in Texas, you gotta sue us in Texas. Because this doesn't involve, or you have to find jurisdiction, somewhere else, because this does not involve an interest in land. That is not what the case law, the history of case law says, that dealing with this venue provision. This venue provision deals with not only legal title, it deals with possession. Leases control possession. They use, I listened to his counsel's argument, and he described what happens on state land as it's occupied, it's possession, we might dispossess them. That's what he said, we may dispossess. All of that goes to Justice Vihill's point. We're not arguing it involves title, because it involves possession. And that, you would be overruling K-Wall if you took out the possession part of an interest in land, because K-Wall clearly governs possession.
What
And
about Team Bank? You'll not have an impact, right?
well, Team Bank was clearly a contract damages case. That was for royalty damages and how they're calculated. It did not involve reestablishing the amount of royalties or doing what was typically called a division order or something along those lines. But I would be very cautious. The foundation of much of New Mexico's economy is based on property rights, mineral rights, water rights, leases, easements. Wind leases are often called wind easements. They're interchangeable. And therefore, the distinction between an easement, which probably is title, at least in my view, an easement is title. It creates a dominant and a servient estate. A lease does the same thing. It provides someone with dominant rights on a piece of property. So I would be very cautious, frankly, to say that because something is a possessory right, which could have massive dollars attached to it, and which is clearly, I think, an interest in land, and is the entire purpose of the control of that land, the possession and control of that land is the entire purpose of whatever documents or arrangements are between the parties. That's simply because there's a contract stating that, which is exactly how royalties are created. Those are created by, they're not typically created by deeds, they're created by leases, as you know, and they can be exchanged by assignments. So to say, okay, this is an assignment of a mineral interest, which is how they're typically conveyed. We're not going to govern possession, to talk about a water rights, which of course is real property, and be very careful that we don't take that language, because what we are doing is protecting a possessory interest. We're not creating.
You're protecting, this is where I'm a little, I do need clarification.
Sure.
I understand you're protecting your client's possessory interest, but your dispute is a contract dispute. The judicial determination that you're asking of the trial court is a matter of contract. And the more difficult concept, it's a matter of state regulation, which, argues pretty strongly against your venues. Isn't it the judicial determination that you request the requested relief? Possessory interest is an outcome, but there's, again, tell me, maybe let me frame it this way. What will the trial court do? They're not going to terminate your lease. What are they doing that you're asking for that's going to change the title of this property or your lease?
What are they going to do?
What relief could the way this is pled, your client's status as a leaseholder is not going to change.
Your Honor, frankly, that's just the same as saying, if we have title, someone can drive across our property and we still have title. Yeah, we do have title, but if they're saying that's an easement and we want to sue and say you don't have an easement, we have to sue to protect our interests. This is the same thing. They're going to put roads, of course. They're going to have construction equipment, of course. They're going to have towers. They're going to have electrical lines. They're going to have personnel. they're going to have possession of our agricultural lease for all of the purposes they're allowed to, which are many and broad in this wind lease. They're sufficient to, they can even build stations where they're not even wind turbines. They're actually where the electricity goes and is somehow processed to be sent somewhere else. So they have free reign to this property on top of our agricultural lease for anything basically related to wind and wind development.
But that might be okay if number one, you agree to it in the contract, and number two, it's provided by state statute. And those are the determinations that need to be made.
I understand you saying it might be okay. That's kind of judging the merits of the case.
But don't we have to, I mean, I don't know what you guys want us to do. People keep saying merits, no merits, merits. Well, we have to figure out what the object of your lawsuit is, which requires us to define at least what you all think the merits of your case is, which is different than generic, just subject. Object means something different.
Correct.
And so we have to look, I think, to where we think you're trying to go on the merits and what the outcome would be to understand what the object is. Because otherwise we would be talking about subject and anything that had anything to do with land. Take the insurance dispute I hypothetical.
Right.
Fighting with your insurance company over whether they properly reimbursed you for flooding in your house involves property and land, then everything would follow.
Well, clearly damages don't fall into it. They're transitory, that
No,
insurance.
but that's a contract dispute that is about land. And if we don't examine what the object is as opposed to the subject,
right,
then every single lawsuit that has as a subject property can be brought where the property is located, and we upend our venue statute.
I think you're about to do that if you carve written leases out of the venue statute because they're in written contracts and say.
It's about what the dispute is, though. I think you are ignoring my concern and Justice Thompson's concern about your fight. You still have a lease. Your lease isn't being terminated. It's something. It's not. It has not been terminated. There's nothing in the record to suggest that. You haven't pled that. And so you're asking us to do something that I think consequentially is much, much broader than is reasonable.
And yeah, that's what I'm struggling with is the provision in that lease that you argue against could be or may not be valid. Your argument could prevail. The question is about where do you get to make it?
Correct.
And our case law is if the object is the title.
The case law is if the possession is the object, not the title. In my view, that's exactly what K-Wall says, and they refer to a line of cases in establishment.
But it's not possession, it's the possessory interest.
Correct.
Possession could be trespass or many other things which clearly are not within
Certainly.
the object. So it's the possessory interest, and the possessory interest is your lease, and you still have your lease. The land office has not asked, I looked at their counterclaim, they have not asked to terminate your lease. So they're not interfering with your possessory interest. You still have that lease.
I disagree. I think that's certainly a factual issue. So if someone puts a lease on top of a possessory interest documented by a lease, which is what we have, as you suggest, to take the position that unless they terminate your lease, they're not interfering with your possessory interest, I don't think that's an accurate statement of law, just to be candid. That's a lease. That would really call into question virtually any significant lease where the landlord can put something on top of your lease and you cannot protect it as long as they don't terminate your lease. But the possessory interest allows certain types of conduct to be conducted, certain investments to be made, and the economy of that lease is based on that type of possession that's in the lease to begin with.
And there
So-
hasn't been any interference with your possession to date, correct? They haven't built any roads, they haven't brought things in, they haven't taken all the grazing grass away. Nothing has happened, right?
We don't know what's happened out there.
Your client doesn't know
No,
whether
we've
there's
sold the
been-
property.
You sold the property.
We sold the property. The case law is crystal clear that, and they didn't raise that, by the way, but they know we've sold it. They've assigned the lease to another. They've allowed,
You sold the property.
we've sold the property and they've allowed the lease to be assigned. We sold the
So is
lease.
this moot?
It is not moot because
Why?
the case law clearly indicates that you look at, for venue purposes, you look at the claims that were originally pled.
You're
Yeah,
no
but now
longer
it-
the lessee though, correct?
So what are your, you have no claims now. Isn't this case by definition moot? You have not asked for money damages.
Correct.
You're asking for declaratory relief that doesn't affect your client at all.
Correct.
I think this is moot.
I think the case law clearly indicates it is not moot. There's two cases directly on point that
What
indicate.
cases are those? Because that's news to me.
First, I'd like to that issue before we came today, Your Honor. and-
So if I could follow up a little bit, please. Your client's possessory interest in the land can no longer be diminished because you sold the lease.
That's true. We don't disagree. with
So you don't have a diminished possessory interest in the land, which is, at least to my way of thinking, would be just a very, very narrow way, you might be able to fall under the land owning statute. So it seems, and correct me if I'm wrong, that what the Chief Justice says, it appears that this case may not have any case or controversy, it's moved. Because you no longer have any interest in the lease, let alone a diminished possessory interest in the land covered by the lease. Tell me if I'm wrong.
Okay, the counterclaim remains pending, of course. So
That's not your claim.
that's not our claim. We're defending that counterclaim, but certainly the counterclaim is pending. It was brought in this venue, possibly as a compulsory counterclaim. I'm not sure. But as I indicated, the question, and when this was certified, our case was pending, but when we filed it, the question I think is, was venue proper when we filed it? And I think that's the law of venue.
Well, not necessarily. I mean, a case can become moot. The other question that's coming up in my mind, can we take judicial notice of that, or how do we acknowledge that fact that's just been made in oral argument? It's not part of the record, it's not part of the pleading, it's not part of the argument.
Well, we're not going to contest that. I can just say it wasn't briefed. There was no notice saying this is moot. State land
They
office.
didn't tell us until today that the land had been sold. So we couldn't direct you all to brief it. That was,
Well,
I mean,
I'm just saying.
I've not had a surprise like this in oral
Well,
argument in 4 years.
Well, what we heard was the state land office wants guidance on venue. So they've determined to pursue this argument in front of you.
Oh, I'm gonna ask the same questions. Don't worry. I'm gonna have
And this is.
the same questions for council.
So,
person,
But
state land office.
let me just cite these two cases for you.
Yeah, that's.
So-
Perhaps it's, counsel?
Yeah.
Perhaps it's a matter of public importance, where there's possibility of repetition, but evading. Is that a possibility?
Yeah, that's possible for the state land office. My client,
Is out of the game.
we're out of the game. And, frankly, we feel we were forced out of the game. We were surrounded by solar after we bought a property that was remote and was for certain values. And we decided at the time to contest this lease because it was on top of our possessory interest. and it didn't follow the regulations, and it clearly involved our possessory interest in our use of our property and our use of our grazing. And yes, we feel we've been forced out. They have a counterclaim that alleges all kinds of other motivations to my client. But if I don't, so let me. So there are two cases, United Nuclear, which is cited in the pleading versus Fort, Court of Appeals, 1985, which cites the Hughes versus Joe G. Maloof Company, 84 New Mexico 516. And when they quote Maloof, they say, venue was proper when the original suit was filed. Cross-claimant was not entitled to change of venue when the original suit was dismissed.
I'm not sure that that answers the question, but I appreciate
But
you
that,
giving
I
us
think-
the citation,
I think those citations,
and we'll take a look.
if venue is proper in the principal claim, it continues to be proper with respect to other pending claims, which is different. But they're citing the Maloof case. In that case, the original claim, which controlled venue, was actually dismissed. And the cross-claimant, which we have here, sought to change venue, and that was denied in the 1973 decision. And I don't think that decision's been overruled as far as we know of. And I think it makes sense because otherwise you file suits and the venue changes in the middle of the suit. So there's a strong public policy indicating that you don't track this claim got dismissed and that one didn't. So let's start over in a whole other jurisdiction or a whole other venue, a whole other county. So
Can I get back to the question that started this, that launched this whole thing?
Yeah.
Which was, if there's nothing that's been done to the property, isn't your client's claim, assuming he still owns the property, speculative, that his right to possess the property is going to be interfered with,
I don't think it is. We have the lease form itself,
right?
which indicates all of the possessory rights that have been given to another third party.
Sure.
And I
but
think
the lease form says that the first 5 years of the lease are going to be creating a development plan, which may or may not have an impact. And as of the time your client sold, it didn't sound like it had any impact on the property. They weren't grading roads. They weren't pouring concrete. And your client had a 5-year lease. Isn't it speculative that there's going to be any possessory interference with your client's possessory right?
Well, you know, that cuts two ways, and that puts any client like mine in a very treacherous position. You wait to file a lawsuit, and of course they're going to say it's late. You had a copy of the lease. You have a contest proceeding that they pointed out. You have a 30-day contest period after that lease, which they didn't provide us notice. So I think their own rules sort of contradict what you're saying, which is if in fact we showed up to contest this in the time period allowed, and based on your argument, they could say we're speculative. So we would not really have an ability to contest this under their way of setting up things, because all they would do is say what you're saying, Your Honor. This is speculative, but you have to do it within this 30 days of execution of our lease.
But you could still file the lawsuit.
No, you can't. If you file a contest and you choose one administrative path,
But I'm saying if you don't file the contest and you just
if you don't file a contest and you have notice, you don't have a claim whatsoever. The reason we have a claim and why this is not catastrophic and not a big issue for the land office, they chose not to give us notice. They chose to eliminate our ability to contest this. That's not what's happening with all these other thousands of acres they have. It's not happening with these other leases. So that's why it hasn't been come to this court before. They own all that land, but they've never had an argument over venue. It's because no one has a right to really challenge their decisions except through contests when they provide notice. So otherwise we'd have dozens of decisions, or we'd have a single decision that draws a bright line. So that sort of parade of horribles, I don't think is really what should be considered. I'm more concerned that not protecting, allowing people to protect their possessive interest, because you look behind what creates the possession argument, and it's a contract, it's a probate, whatever it is, you look beyond it and you call it transitory, when it actually is affecting the possession of the property. And I think that's really what the heart of this is for these extremely valuable possessory rights. Are people not going to be allowed to protect them as an interest in land? And I think they are interested in land.
Just to some more, do you have any questions for Mr. Domenici? I just want to make sure we don't leave you out because I'm not watching to see if you're waving your hands or not.
I do not. Thank you for asking.
Thank you.
Okay, if there's no further questions, then I don't have anything else.
Thank you very much.
Thank you.
So you should probably tell us why we can still go down this rabbit hole.
Right. And I certainly didn't mean to withhold any information that might be of importance to the court on this. And I thought the initial answer to the question as to whether the case was moot was no. And then the answer seemed to have changed from that. I'm not quite sure where we are, but the court has its own, I think, concern about mootness, and I'm happy to address that. So firstly, the assignment of the lease requires the consent of the state land office, and that hasn't happened. So the lease has not been assigned. They are still the lessee, and under the lease, they have an obligation, if nothing else, to prevent trespass and waste out there. So if they're not doing that, they've got a problem in terms of that particular compliance with the lease. In terms of whether they ever were running any cattle out there, I don't know the answer to that either. That's not in the record either. What we do have in the record is a copy of the lease that shows that there are no improvements. And so we don't have anything, as was noted, in the record as to mootness. I can represent to the court that state of affairs, which is that assignment of the lease requires the consent of the Commissioner of Public Lands. They have asked for that consent and it has not been granted. And so they are still the lessee. If there's
So we have
something
more facts outside the record.
correct. And so I think because I'm trying to be responsive, because I understand that the court has a concern about this. And so
So I have two representations of counsel.
Right.
One is that the lease has been sold and transferred, and a representation that the consent to that transfer has not happened.
correct. And so there is no transfer absent consent. I think for purposes of mootness, the court can develop a record. We can make filings with the court to sort of give an indication in terms of if the court wants to examine this and determine. And we can make those filings and examine the law and make arguments about that. If they want to argue that it's moot, they can do that in that context. I'm a little, right, in terms of the court's own concern, the court's not bound by the district court record. There should, if it really wants to examine that, maybe you want to have a fuller record. And so I'm not here to sort of try to I'm happy to make a representation in terms of what I understand the facts to be.
Is it accurate to say that since this case is up here, nothing has happened? There haven't been any dismissals or anything in the district court either, or attempts to dismiss?
Correct.
Okay.
Yeah, there've been the only things that have been filed in the so it was mentioned. So when the motion to dismiss was denied, it included an order that we comply with the 10 days to file an answer, which we did, and which included counterclaims, and which included in it, and that we've included on our brief, how you can make a compulsory counterclaim without waiving your venue objection, right? So the fact that counterclaims have been made doesn't mean that we've waived our objection to venue. If court orders a dismissal for improper venue, we're happy to deal with our counterclaims in some other way.
I was more asking whether the Blanchard parties had tried to dismiss their claim against the land office after selling the property.
No, there's been no effort to.
Or substitute parties or anything like that.
No. Nothing of that order. I was just trying to be clear in
thank
terms
you.
of whether, what proceedings have occurred in the district court
So
subsequent to the denial of our motion.
getting back to the venue issue, let's assume for purposes of discussion that the complaint clearly says, count one, the land office didn't follow proper procedure. Count two, that I want possession, full possession. Because of that, I want full possession, the full leasehold possession. Same rates, would you be making the same argument? That venue is improper.
Yes,
Tell me why.
because it's
Isn't
not,
that a leasehold, isn't that a possessory interest in part of, isn't that an object of the lawsuit? In part is to preserve possession or leasehold interest.
well, I think as Justice Thompson has noted, there's a contract. Now, whether that's a owner, some kind of interest in land for purposes of paragraph D, I think is somewhat uncertain. And so it's not clear as far as the state land office lease, whether that is a leasehold interest.
Gotcha.
And certainly there's no title record in the county as it relates to that. The
Gotcha.
record as to state land offices is here. I did want to make an additional clarification. Mr. Domenici said that the relief in the prayer for relief was that the wind lease, as I understood what he said, is the wind lease is void and unenforceable, and that's not the request for relief. So the prayer for relief says, wherefore plaintiff requests that the court enter a declaratory order finding that in issuing the wind leases, the commissioner failed to comply with the requirements of NMAC 192921. Plaintiff further requests an entry of a declaratory order that section 21 of the agricultural lease regarding renewable energy is contrary to and in violation with the rule and therefore is void and unenforceable. So it's not about, there are no requests there, and there's parsing that's required in terms of determining venue. And in terms of voiding that lease, the wind lessee isn't a party to this case. So if you were trying to void, if that's what was going on, you would think that the party whose lease was being voided would be present, and they are not. I think you can look at things like injunctive relief, which K-Wall talks about. Is it injunctive relief that's functionally equivalent to a quiet title or something on that order? It looks at a case where the injunction is requested that the defendant be enjoined from making any claim of ownership of the property. And the court says, well, that's functionally equivalent. And that puts you into paragraph D. But the injunctive relief that was requested in K-Wall is distinguished and says, well, that's not an ownership injunction. It's not an in rem type of relief that puts you into paragraph D. And when you examine, K-Wall doesn't talk specifically about declaratory relief, but I think the same kind of thing applies to declaratory relief. Is it functionally equivalent? And here, the requested declaratory relief is not functionally equivalent to a quiet title or something on that order. The one other clarification I wanted to make, given some of what was said, there was a reference to easements. I think it's noteworthy that we can grant easements without getting any consent. We reserve the right to grant easements. So we could, if we wanted to characterize wind turbines and the associated facilities as something that somebody could do under an easement, that we have every right to grant that without getting any consent. And that's not what we're doing here. There also was a reference to the contest and the ability to file a timely contest. Contest rule has a lot of flexibility in it for somebody who is not within the 30 days that's in the rule to say look, I should be getting an accommodation. I don't have the text of the rule in front of me, but we made a exhaustion argument. We're not here to talk about that, but I think since it was discussed here that somehow we were trying to deprive them of some opportunity to be heard, that it was important that we made the argument in the district court, that they do have the ability to file a contest and to ask for an accommodation with regard to the 30-day rule. Because the rule says specifically that their accommodations can be made. Unless there are any further questions from the court, again, what we're asking for is a reversal with instructions to dismiss the case for improper venue. Thank you.
All right, thank you, counsel, for your presentation today. The case will be being submitted as of today, and we will get to a decision as time permits. Thank you.
Agenda 4, please.